Hello, friends. Welcome to our panel, May It Please the Court. I'm Jeffrey Rosen, and I'm thrilled to be joined by two of America's leading Supreme Court advocates. On my left is my brother-in-law, Neil Katyal. This is the latest installment of our running podcast, Brothers-in-Law. Neil, as all of you know, is coming off of his historic victory in the tariffs case, which the New York Times called the most important Supreme Court case of this century. And he's argued more than 50 times before the Supreme Court and has a series of other extraordinary victories. And he's joined by his former partner, Katie Wellington, who works at Hogan Lovells. Katie has been involved in 12 Supreme Court cases. Her victories include Moore v. Harper, the Supreme Court elections case, which she worked on with Neil. I should say that Judge Michael Ludig called the Moore v. Harper case the most important Supreme Court case in 250 years. So both of them are doing very well on this score. Neil, Katie, and I had a great hike up Smuggler's Mountain yesterday, and we talked about this panel, and our goal is to give you both a unique window onto what it's like to argue before the Supreme Court, how to convince the justices and to win your case, and also to have a really intense and illuminating discussion on the Roberts Court at just over 20 years, how it's changed, what it's like today, whether or not it is political, whether or not it is likely to check the president in the two remaining big cases that will be decided probably next week involving birthright citizenship and the president's ability to fire the head of the Fed, and more broadly, what you should think about the Supreme Court. So I'm really excited for the discussion. Neil, we have to begin with you and tariffs. How did you win it, and what does it say about the court?
Okay, so first of all, this is probably my 15th year in a row speaking at Aspen Ideas. It's the only conference I do every year. It's just because the extraordinary people in this room. And so thank you for being here. Thanks, Jeff, for having me. So the issue in the tariffs case was whether or not the president could impose unilateral tariffs on the entire world, tariffs that went from 15% to 145% for as long as he wants, just by his say-so. And his argument was, well, it's not really my say-so, because in 1977, Congress passed a law, the International Emergency Economic Powers Act, which gives the president, in a time of emergency, 9 powers. And one of those powers is the power to regulate importation. And regulate importation is the phrase, and you would think, well, what is a tariff but a regulation on importation? So we face the challenge with a court that claims to be textualist of saying the president couldn't do this. Now, we had a couple of things working in our favor, but we also had a couple of things working against us. Most prominently working against us is the Supreme Court has rarely, if ever, struck down a president's signature initiative over its 250 years. Maybe the New Deal, but even those weren't the key parts of the New Deal that the Supreme Court was involved with. But maybe that's one example, but that's it. And so we're asking the court to do something that it had either never done or maybe been done once before in history. On the other side, regulate importation. The phrase regulate is used over 1,000 times, 1,499 times by Congress in the United States Code. It's never meant the power to tax. It's never meant the power to take money out of your pocket and put it into the federal treasury. So we had the burden of really just trying to say regulate importation doesn't include this. And so my opening words to the Supreme Court was tariffs are taxes. And that was designed to distinguish it from other regulations on importation. For example, Justice Kavanaugh in the oral argument came after me and said, look, you say the president could blockade all goods from a country or from all countries, right? And I said, yes, that's a regulation on importation. So then he said, why isn't the lesser power the power to tariff? That's letting the goods through, you're just paying a price. And that's where, and if those of you who just saw the Ken Burns amazing discussion a moment ago, where American history came in. And I said, Justice Kavanaugh, we didn't have a Boston embargo party, we had a Boston Tea Party. And the Tea Party was meant to capture the idea that, when you're taking money out of pockets and putting it into the Treasury, that's a distinct harm that our founders understood. And so as a distinct harm, you needed to have special authorization from Congress for that power. So that's the intellectual side of this. The more practical nuts and bolts side, I was terrified. Yes, it was my 53rd argument at the time before the Supreme Court, but the stakes were astronomical. We have been living in an age in which there have been almost no checks and balances. Congress has been entirely asleep at the switch, and this case took on an importance way beyond tariffs. It was about restoring the checks and balances of our democracy. And I was nervous as all heck, despite all of the other arguments I'd had. So I did a couple of weird things to prepare for this argument. One is I started working with my improv coach. I've been taking improv comedy for the last 6 years. And you might say, what does improv comedy have to do with the Supreme Court? The answer is actually everything. Because my coach taught me the power of listening, the power of yes and, the power of trying to take a question which comes at you in a very hostile way and accept the premise of it and build upon it and make it less adversarial. So that was one thing that I did. Another thing I did, and I think, there's been a little bit of a theme at the Ideas Conference about this, but use of artificial intelligence. I worked with a company called Harvey to create a bespoke AI that was trained on every single question asked by a Supreme Court justice in the last 25 years and everything they had written. And we used that to start to help to predict what kind of questions the justice would ask. Now, we do this, of course, with humans too. Katie and I used to do it, Katie Clerk for the Chief Justice. And I would go to her and say, what kinds of questions would the Chief Justice be likely to ask? Harvey started to automate some of that. Still, there's a lot that Harvey can't do. If I just use what Harvey told me to do, I would have lost 10-0 at the Supreme Court, and there aren't even 10 justices. All of that's, it's helpful, but it's just a tool, and there's a lot of problems. But we will see over time advocacy change because of these new tools. The last thing I did, and this goes to oral argument of the Supreme Court, it's an unusual thing. You're 10 feet from the Chief Justice. The other 8 are splayed out across about 50 feet. You can't actually see all 9 at any time because of peripheral vision. You just can't do it. You can only see about most of the court, but not all. It is very much, about oral advocacy and trying to make sure in the heat of the moment you don't say something that's going to gut your case. About a month before the argument, I met a guy named Ben Crow. Ben is one of the top sports performance coaches in the world. He coaches Andre Agassi, people like that. And we got talking, and he said, I think I could help you because what I do is basically prepare people for game day. And you're facing this incredible game day. And I started working with him, and he instantly got me to admit something, not instantly, but over the course of a day, got me to admit something that I didn't really understand about myself, which is I had massive imposter syndrome, that every time I'd go to the court, I'd look at those portraits of the people. They don't look anything like me on the walls, and I never felt like I totally fit in. And he helped me understand that and figure out how to deal with it. And the story's almost over, so I promise. The day before the argument, he calls and says, how do you feel? And I said, I'm terrified. And he said, why are you terrified? I said, I got to restore the checks and balances for, our democracy. I got to remember 10,000 things and get it all right. I got to not just freeze at the podium. And he said, Neil, this sounds hokey to me, but why don't you change the vowel? I said, what do you mean? He said, well, change the O from got to E and get. I said, what do you mean? He said, well, tell me what you get to do. And instantly it pours out of me. I get to defend the Constitution of the United States. I, the son of immigrants, get to remind the country about its founding values. I get to defend the rule of law. This all just pours out of me. And then for the next 18 hours, I was just psyched. I was completely psyched. And the argument went well. And yes, in a 6-3 opinion by the Chief Justice, the tariffs were declared illegal. $166 billion now going back to Americans who paid those tariffs. Nothing in economic value has ever been like that at the court, but I don't think it's about dollars and cents. I think it says something profound about our system, about our founders' genius, that they could set up something in which they knew our leaders were going to make mistakes, and they found a way to self-correct it, and that's what happened.
Wonderful. Thank you for that inspiring introduction. Katie, you argued and won unanimously a case last year called Royal Canin. You also clerked not only for the Chief Justice, but also for Justice Kavanaugh when he was an appellate judge. And what I'd like your thoughts about is, first of all, was it unusual to win a case unanimously, or is that more the norm than these 6-3 decisions that everyone's talking about? And should we think about this Roberts Court as a hotly divided 6-3 court, or is it more the kind of unusual victories like the one Neil just won, or this gun case this year, the Pinchford case, where the court 5-4 with Chief Justice Roberts and Justice Kavanaugh joining the liberals overturned a death penalty conviction on the grounds of racial discrimination?
So I think it's a really great question because the Supreme Court, you only really hear about the tariff cases and the birthright citizenship cases, and those are really important cases and they impact a lot of people. But there are a lot of instances where you don't get the impact or the result that you're expecting. So we just represented someone who's on death row, Terry Pitchford, and the conventional wisdom is you should not take a death penalty case to the Supreme Court because you will lose. And I've done it twice, and I've won twice. And I've won twice 5-4. And I really have had conversations with people across the legal world that says, just don't take that case, don't go, because you're going to lose. And I think the key is you have to think about each one of these justices and what they care about and try to figure out exactly how to get there. So this Pitchford case was a very important case. It was a case about racial discrimination in jury selection. And this case was not 40 years ago. This case was like 20 years ago. And there is evidence in the record that the prosecutor went down and wrote the word B next to the black jurors and the word W next to the white jurors. And he struck every one of the black jurors except one. And that is just clear from the record. There's no dispute about that. But the state court in Mississippi nevertheless held that even though there's this clear constitutional violation, the lawyer didn't raise it clearly enough. And I will tell you what this lawyer said. This lawyer said to the district court, I want to raise and preserve my Batson violation. And the court said, sure, it's preserved. That's what the court said. But then when it gets up onto appeal in the Mississippi Supreme Court says basically, I don't care what that lower court judge said. You didn't preserve this argument. This person stays on death row. And so there's this incredible injustice there. And one thing that the Supreme Court does care about is injustice. And one thing that both the Chief Justice, and you can see this in some of his earlier opinions, and Justice Kavanaugh care about is race discrimination, including in jury selection. And so writing that story, this isn't a death penalty case, this is a race discrimination case. And how do you make that right? And even though the Supreme Court in many cases is about the entire country, sometimes it's about one life, and you can tell that story. And so you have to use your storytelling powers to really move the court, and sometimes you can succeed. And so that was an incredible victory that I think a lot of people weren't expecting this year.
And I would just, I could just add to that.
Yes, but I want to set up no, go ahead.
So, I do think Katie's absolutely right that people get the prediction. There's all these so-called predictions of how the Supreme Court's going to rule, mostly on political grounds, and they turn out often to be wrong. Like the year after Citizens United, which was the big case that said corporations have free speech rights, I had a case called FCC versus AT&T, which all the newspapers were billing as Citizens United Part 2. Citizens United was, do corporations have free speech rights? In this case, there was a law, the Freedom of Information Act, and it had an exception for personal privacy. And AT&T, as a corporation, said, we are persons, we have privacy rights. And so everyone is saying this is going to be a same 5-4 decision. Do companies have property rights, have privacy rights? So the lawyer for AT&T stands up at the podium and he says, my argument's very simple. There's an exception in the law for personal privacy. That's the phrase. Then he says, corporations are persons. If you look at the Dictionary Act, which is the first law in the United States, it's defined, if you look up persons, it includes artificial persons, corporations, and natural persons, you and me. So he says there's an exception for personal privacy. Corporations are persons, ergo AT&T is protected by this exception. The Chief Justice immediately interrupts and says, well, wait a minute, you're giving me the definition of person, but the word is personal. Shouldn't that make a difference? AT&T lawyer says, I don't know what you mean. The chief says, well, sometimes words have different meanings from their roots. Lawyer for AT&T says, I don't know what you mean. Chief says, let me give you some examples. Craft, crafty, squirrel, squirrely, pastor, pastoral. Lawyer for AT&T has no answer to this whatsoever. And sure enough, 6 weeks later, unanimous opinion written by the Chief Justice ruling against AT&T. And I kid you not, the very last line in the Chief Justice's written opinion for the Supreme Court is, quote, we trust AT&T will not take it personally.
Huh.
And,
Wonderful.
and this is why Neil has an improv coach, because you don't know what you're going to get, right? You got to be ready.
Katie, let me ask you about Chief Justice Roberts. You clerk for the chief, and how has he changed over the past 20 years? I had the extraordinary experience of an interview with him at the end of his first term in 2006. And he said, Professor Rosen, I'm concerned that this court is acting too much like law professors than members of a collegial court. I'm worried that the country is polarized, and it's important that they see the court as something more than politicians in robes. And I'm going to make it my goal to promote narrow, unanimous opinions, like my hero, Chief Justice Marshall, so that people can converge around results rather than being as polarized as the other branches. He had some limited success with that vision during his first 15 or so years, most notably in the healthcare case, where he voted to uphold Obamacare and avoided striking down a president's signature initiative. But ever since the death of Justice Ginsburg and her replacement with Justice Barrett, we've seen a new chief. And some have said he's become far more conservative. In the immunity case, he's taking the lead in broad, sweeping conservative opinions. Has he completely abandoned his earlier vision? Or, as he told me, he said, if it doesn't work, we'll try another approach. Is he just adjusting to the fact that he no longer has the votes for narrow, unanimous opinions?
So I think it's a really important question, and the court has obviously changed so dramatically. When I was clerking on the court, Justice Ginsburg was still there. She left every night at 9 p.m. She was the hardest worker on the court, and she left right by my door to my elevator. So I waved at her, every day at 9 o'clock as she was leaving. And I think her influence on the court has really, really been missed, and the court has just changed so much over time. The chief has not changed in the sense that he cares so much about the institution of the court. He cares about how people perceive the court. And you kind of see this in his opinions. I think some of the opinions that people really disagree with, like Trump against the United States, which held that the president is immune from pretty much everything. But I think that was motivated by his desire to keep the court out of politics. And a lot of people criticize it because they say, well, if the court doesn't step in and doesn't do this constitutional job that it is supposed to do, that's actually the court, being viewed as a political body. So I think that's something he struggled with. But it has very much changed from when I was on the court and Justice Kennedy was at the center. And Justice Kennedy was at the center, and everyone, you're walking around the court and everyone's knocking on Justice Kennedy's door because they want Justice Kennedy's vote. And for a brief period of time, it was the chief. The chief was in the middle of the court, and he got to sort of play that chief justice role in a swing vote court. But he is not at the middle of the court anymore. So I think that goal of getting 9-0 unanimous opinions is just very, very difficult. The court does it. And you see that sometimes. You just saw this in a Second Amendment case involving guns and marijuana. And I never thought that would be a 9-0 opinion at the Supreme Court. where you had the whole court agreeing that just the mere possession of marijuana is not enough for you to lose your right to bear arms. So there's an example of a 9-0 opinion. But I think it is difficult for him now because he's not in the middle of the court. So despite being the Chief Justice, he, I think, has to deal with a dynamic where he can't get to 9-0.
That's very helpful. And just to remind our friends about how the court works, when the Chief Justice is in the majority, he can either write the opinion himself or assign it to the justice who best reflects his views. If he's in the minority, then the senior minority justice, who in this case would be Justice Sotomayor, I think, either writes it herself or assigns it to whoever he likes. So if Chief Justice Roberts just doesn't have 5 votes, in order to keep the ability to assign the opinion, he has to either go more conservative or file a concurrence or dissent, which he doesn't like to do. Neil, speaking of gun cases, it wasn't a total triumph for you this term. You did just lose a case involving guns in Hawaii. You argued that there was a tradition of gun regulation in Hawaii dating back to the Civil War when the infamous black codes prohibited African Americans from carrying guns. The majority dismissed that as not a relevant tradition, even though they've said that tradition is the role. So how has arguing before the Roberts Court changed for you over the past 20 years? And obviously you have to make a lot more arguments about text, history, and tradition. How principled and consistent is the court in evaluating those arguments?
Yeah, so it's true. I lost the Hawaii gun control case 6-3 2 days ago, so I'm still smarting from that. It is hard to win gun control cases at the Supreme Court. That's a little bit of an understatement. But nonetheless, I do think that, Jeff, your broader question, like how are things different? I think this court now comes into oral arguments with their minds more made up than in the past. My first argument was Guantanamo. I won it 20 years ago today. The question in the case was basically, it was Guantanamo a legal black hole in which the president could do whatever he wanted. And the Supreme Court, in a 5-3 decision, said no. And Justice Kennedy was on the court at that time. And Justice Kennedy, you could see him visibly struggling on the bench as to what to do. Not struggling in the sense of intellectually not capable, but rather so intellectually capable that he saw the arguments for what they were on both sides. It was an incredibly hard argument. And he's sitting there struggling. I think, Jeff, once at one point you wrote a New Yorker piece called The Agonizer or something like that about Justice Kennedy. And that was generally his MO, which was really understand the best arguments of both sides coming into the bench and then listen, ask really hard questions, and you weren't really sure which way he was going to go. I think that's also true about Justice O'Connor when she was on the court, and Justice Souter to a lesser extent. Now, the confirmation process has gotten so different that basically presidents are only sending up sure things. Like I had the privilege of clerking for Justice Breyer. There's no way Democrats would ever nominate a Justice Breyer today. He was far too independent than what the kind of political base demands. And so a lot of times you hear criticism that justices are acting politically. I don't think the justices are acting politically. I think that they're in general doing what they said at their confirmation hearings they were going to do. They're just much more sure things than some of the justices that we've had in the past. So how does that matter practically? Well, here's one way in which it really matters. You all may remember just 4 years ago, the Supreme Court issued the Dobbs decision overturning Roe versus Wade and saying that it's up to states to decide reproductive justice. Now, overturning Roe versus Wade was not some small thing. Indeed, it was considered a super precedent, the hardest thing for the court to overturn. Indeed, Justices O'Connor, Kennedy, and Souter said so in 1992. They said, our rock of the law is stare decisis, respect for precedent, and this case sits on top of that. And yet this Supreme Court threw it out and overturned Roe versus Wade. If you can do it to Roe, you can do it to any case. And so, as a practical matter, like when I started arguing before the Supreme Court, my first Roman numeral in my brief would be, you've already decided the Supreme Court, precedent compels the result. Now, I don't even have that section in the brief, or if I do, it's at the very end. Instead, it's all first principles command the result for my client. So it's a real shift in how advocacy is. I agree with Katie that the Chief Justice, I'm a fan of the Chief Justice. I think he's done as good a job as he could in institutionally demanding role when he's got 5 justices well to the right of him on many issues and 3 well to the left. It's a really tough place to be. I will say, though, he has issued 2 opinions, which I think will make it hard for him to go down. I'd hoped he'd be one of the greatest Chief Justices in our history, rivaling Chief Justice Marshall. But I think the Trump immunity decision is really, really hard to defend. I understand it's maybe arguably keeping the court out of politics, but the most foundational rule in our system is no person is above the law. And I don't know how you, particularly if you care about the view of the founders, how you can reconcile that principle with the idea that the president can do whatever he wants, even to the point of assassinating his political rivals, and the criminal law has nothing to say about that. That just can't be our Constitution any day of the week. And then his opinion upholding, and this was one of my cases, I lost it 5-4, upholding the Muslim ban. Something so deeply corrosive to what America is all about. So, I look with hope and optimism to the future.
Katie, respond and reflect, if you will, to the charge that it's all politics before the Supreme Court. This is what many Democrats feel. There's a tremendous difference in approval among the court for Democrats and Republicans. It's about 13% for Democrats and 84% for Republicans. As a result, it's hovering just below 50%, whereas before 21, it was substantially above 20%. But Justice Breyer said something that I remembered in a conversation. He said it's not partisan politics before the Supreme Court, but political philosophy. And if you're a small government libertarian or a fan of big congressional or executive power, that'll guide your decisions. And I've just surveyed American history through the lens of Hamilton and Jefferson, and am inclined to conclude that from the beginning, the court has divided among Hamiltonians and Jeffersonians. Hamiltonians favor strong national power and a strong executive. Jeffersonians weak executive and constrained national power. Hamiltonians are liberal constructionists, Jeffersonians are strict constructionists. And what would you say to the claim that on the current court, that Republicans tend to be Jeffersonian on congressional power and Hamiltonian on executive power, and the Democrats are the exact reverse?
So I cannot deny that the view of the Supreme Court that these polls show is as a political entity. I think when you're inside the court, the justices aren't going, oh, I want to vote for President Trump or I want to vote for President Biden. That is not how they're thinking about it. They're thinking about it as a legal theory. But I think it's interesting to think about where those legal theories come from. I think they come from the law schools. And I think there's been this huge change in conservative legal thinking through the law schools over the past 20 years, really starting with Justice Scalia in the Federalist Society. But there's this whole, the Federalist Society has things just like this in cities all over the country, like every month. And there's all this thinking. And the thinking, I think, a lot of people view it as in a particular political camp. So I think it's, you go to law school and you go to lectures like this, where there's this conservative way of thinking. And part of that is deference to the text. We don't actually care what Congress was trying to do. We just care what they wrote on the piece of paper. So that's one way of thinking. And another way of thinking is this sort of structural constitutional view of what the founders meant was for the president to be the executive, and nobody else gets to make the call. The executive agencies don't get to make the call. The people, the Merit Systems Protection Board, the civil servants, they don't get to make the call. It's the president. And if you take that view of the Constitution and you learn that view of the Constitution in law school and you take it with you as you become a lower federal court judge, then I think that informs your thinking of when you get to the Supreme Court, how you think about these issues. And so I do think it is very much legal ideology, but I think it comes from these schools of thought that have grown over time, and I think some people view as connected to political ideology.
There's no question that the Federalist Society, love it or not, has been the most influential movement for legal and political change of the past half century, and it's been tremendously influential. However, on our hike yesterday, we were dividing the conservative justices into different interpretive camps, suggesting that they're not all, they don't always agree. And I think we suggested that, Katie, I think it was you who called Chief Justice Roberts and Justice Kavanaugh structuralists who care about the relation among the branches, and then Justice Gorsuch, a textualist above all, and then Justice Thomas, and more of an originalist who cares about original understanding. And I think we weren't quite sure about Justice Alito, although I did remember the famous comment of Justice Holmes on one of his colleagues, Justice McReynolds, who said that the essence of his jurisprudence was, God damn it. Neil, you argue before these conservatives. Are they all alike, and how would you characterize their approaches?
Yeah, so first, just on what you were discussing with Katie before, I mean, my test when I was running the Solicitor General's office for any legal issue was, imagine it wasn't President Obama, I was in the Obama administration, imagine it was President Bush, would I still have the same view? And I think that's just essential, that's what you learn on day one of law school, reverse the identity of the parties. I'd hope the 9 justices are doing that. It's not always clear that they are. That concerns me. Let me give you a very concrete example. Jeff, you said the big originalist on the court is Justice Thomas. 4 years ago, I had this case, Moore versus Harper, which you heard just a little bit about at the beginning. That was a case about the independent state legislature theory. That was this idea that basically in presidential elections, the ultimate decision makers were state legislatures, not the people. And so they could even throw out the votes of the people, and the state legislatures would decide the electoral votes. This was a big theory in 2020 that the Trump folks had floated and the like, and so the stakes were very large. And when I took the case, everyone was predicting, all the media and stuff, we would lose. The RNC had put millions of dollars into this theory. If they could win this case in the Supreme Court, it would entrench Republican control over presidential elections for decades. Big, huge stakes. I looked at it and thought, this is a totally winnable case. Why? Because this court claims to care about the original understanding of the Constitution, what the founders was, and that is clear as day that this theory that the Trump folks had was poppycock. So I'm preparing for the argument. I do my usual crazy number of moots and stuff and the like, but I did have a secret play, which I didn't even let Katie know about because I was worried that everyone was going to say no and not let me do it. So here's what happens. I give my opening to the Supreme Court. Justice Thomas asks the first question, as we knew he would, because that's under the new rules, basically how it unfolds, given his seniority. He asks the first question. He asks me the question. I have no idea what the question is. I don't remember. I answer it. And then I say, Justice Thomas, in more than 2 decades of arguing before you, I've been waiting for this case because it speaks to your method of constitutional interpretation, the original understanding of the document. And here's what you need to know. And then I had minutes on Hamilton and Madison and, Jefferson, all about this. And that, the whole tenor of the argument changes because I'm able to get all of this historical stuff out. And sure enough, we do win the case 6-3, but I don't win Justice Thomas's vote.
Well, Katie, that is the objection to originalism, and it's made very forcefully by the liberal justices, is that it's a kind of whack-a-mole, that the conservatives are switching among text, history, and tradition in order to reach preordained results. By contrast, many are watching Justice Barrett carefully because she seems interested in being a principled originalist and recognizing its limitations. And in her new book, she said that although originalism was originally sold as a way of constraining judicial discretion and having judges defer to the political branches, she acknowledges it doesn't do that because history is very malleable. But she says the virtue of originalism is at least it anchors the decisions and the debates in text and history, and that's a good thing. What do you think of Justice Barrett's approach?
I think Justice Barrett is one of the most honest of the justices in the sense that she recognizes the limitations of her approach. And you can actually see this in some of her decisions. One thing that I like practicing before the court is that you actually don't know what Justice Barrett is going to do in advance. You actually feel like you have an opportunity to sway her. both by coming up with the best arguments about the text and the history, but also, what actually makes sense. I think she is a justice that cares about what actually makes sense. So I actually have a lot of respect for her and the honesty there. And I do think that's something the court is struggling with. And it's interesting because one of the things we do as lawyers is write amicus briefs. And amicus briefs now, like if you're going to write amicus brief, you better just talk about the history. I mean, I have associates in my practice where I'm like, go back to 1776 and tell me what they were doing in Massachusetts. And they're like reading through these dusty books that aren't even digitized. But that's what the Supreme Court cares about. And I think it's very hard to know how to do that and how to do that well. And you saw this really recently in the Second Amendment case about marijuana, where, the justices are kind of saying, well, can you actually analogize marijuana to laws about drunkards from 1776? Like the analogy doesn't really work. And even the conservatives, I think, are recognizing in some cases, in that case, that analogy, the government was trying to say, well, you could keep guns away from drunkards in 1776. So if you're, have a tiny amount of marijuana in your person, we can take your gun away. And so I think that the Supreme Court rejected that because these historical analogies don't always work. So I think Justice Barrett is really the justice to watch. I think she is the vote when you're going to the court that you think that you are most likely to be able to sway in some way. And so there's going to be a lot of focus on her going forward as a really important, and I think she'll be a more and more influential member of this court as the decade goes on.
Neil, in your Hawaii gun case, Justice Barrett and Justice Jackson disagreed about the relevance of these racist laws from the Reconstruction era that forbade African Americans from owning guns. And Justice Barrett said, first of all, it's not the right level of abstraction, but even if it were, it was just Hawaii, so it wasn't a widespread tradition. And Justice Jackson said, this is ridiculous. You don't get to pick and choose among your traditions. It was just on point. How do you deal with that as an advocate? And more broadly, how do you feel the court is dealing with history and tradition?
So first, I want to very much second Katie's into what she's saying about Justice Barrett. I think she's a remarkably interesting justice and someone who's just starting to come into her own. But I do feel like from the start, she always was listening hard at argument and asking hard questions. But you do feel like she's more her own independent justice now after some years on the court. This is true of many justices. Justice Breyer is the same way. I clerked for him in his second year. Far less comfortable going out on his own back then as he was later. So I think we may see a similar trajectory with Justice Barrett. But with respect to the Hawaii gun case, absolutely, I saw massive inconsistency. So the deal is the Supreme Court has said in order to justify a gun control, you have to find analogies back at the founding to that gun control law. Now, that's obviously pretty hard to do most of the time because, society's advanced quite a bit in 250 years. And whatever those legislatures did back then didn't really apply, it's a different world now. But with respect to this, Hawaii passed a gun control law that said if you own private property, a restaurant, a bank, whatever, you had to affirmatively invite guns onto your property. You could do so on the web. You could do so with a sign, whatever that said guns welcome. If you didn't have the sign, then guns were presumptively not allowed. Hawaii had 4 examples of this from the founding that did exactly this. Supreme Court said, well, that's not enough. And one of them actually was from Louisiana and designed to basically keep African Americans away from guns. Now, what Justice Jackson says in dissent is, look, you majority set up this test to look back to history. Here you've got a state saying astounding 4 times the exact same law was passed. You don't get to discount it just because you think it's a racist law or something like that. The test was, are there relevant analogies or not? Here there are. I thought that she had the better version of that argument, and this is what I worry about history. I do think that the goal of the court should be to understand the original intent of the document, absolutely. But sometimes it's deeply contested. Take, for example, and sometimes it's not even deeply contested, it's just contested. Take the birthright citizenship case, which we'll hear being decided probably on Tuesday of this week. The question in the case is whether the first lines of the 14th Amendment, which say, if you're born in the United States, you're a citizen, whether they mean what they say. And the Trump administration has got a couple of bizarro historians who've said, oh no, that's not what it says. The historical consensus on this is very, very clear. But the problem is with originalism is, if you're a justice and you want to get to a certain result, there's always something for you to point to. There's always some historian or some amicus, friend of the court brief, that's going to say, oh, history supports what the other side is doing. And so it's not as much of a constraint, and that's why I was glad to see Justice Barrett in her book acknowledge it.
Well, absolutely, history is complicated. As we learned from Ken Burns, his most inspiring message is that there are no binaries, and it's impossible to give a clear historical answer to any question. It requires nuance and complexity. Katie, defend, if you will, the court against the charge of being fair weather or inconsistent originalists and of abandoning the methodology when it doesn't suit its purposes. You can take some of the other cases that have been decided this term, including the immigration cases, which were a hotly contested 6-3 conservative liberal split, or the gun cases. But what would you say to the critics of the court who say that they're just using the methodology opportunistically?
I think you have to look at each one of these cases on their own. And I think that's something that is important to keep in mind. You can actually go to the Supreme Court website and you can read the opinion. And there's a nice little summary up front. You can go and listen to these oral arguments. And I think it gives you a much deeper understanding of the complexity of what these judges and justices are thinking about. I think we're going to see this with the difference between the birthright citizenship case, which I think I've listened to the argument. I think most people expect, you don't know, but most people expect that the president's going to lose in that case. And the border case that just came out. And the border case that just came out was about whether the border agents can stop you at the border, 5 feet from the border. And if you can't step over the border, can you not apply for asylum law? Because asylum law says that you have to be in the United States. And so that whole case basically came down to the word in, which is sort of an absurd result for something that has such a deep impact on so many people. But I think the members of the court that said you have to be in the United States were looking at that language and saying, this is what we think that language means. And I don't think they were saying, I'm going to vote in a political way. They're saying, this is what I think this language means. And I read the Constitution in a way to give the president authority over foreign affairs. That's what I thought they meant in 1776. I think it was interesting what Ken Burns said, that Article 1 of the Constitution is Congress, not the president. So it's sort of, I think that's a little bit of a shift maybe in this court that I think really, really cares about the power of the executive. And so when you think about those cases, which I do expect to go in two different ways, I think you do have to take them on the facts of the case and try to step out of the politics at least a little bit.
Neil, one of the biggest criticisms of the court being political involves the shadow docket. And as many have noted, the president has been winning roundly on the shadow docket. I think you said Justice Sotomayor was in dissent in almost all of those cases. And yet on the merits, sometimes there's a reversal and the court's willing to rule against him. What's going on there, and is the court being political on the shadow docket?
Okay, so the shadow docket refers to the emergency docket of the Supreme Court. So like when I ran the Solicitor General's office as a top lawyer for the federal government, if we lose a case in the Court of Appeals and say the Court of Appeals stopped something from going into effect, say Obamacare or something like that, we would then have the ability to file an emergency petition to the Supreme Court and say, hey, don't hear oral argument right now, but stop this terrible lower court ruling from going into effect and preventing us from doing the Affordable Care Act or whatever. This is something that Solicitors General did incredibly rarely. In my 2.5 years there, I think I did it once. Justice Kagan, who preceded me, maybe did it once. Very, very rare. The Trump administration's done it, I think, 24 times, and they've won 20 of them. And these are big things. The only one they lost was the deployment of the National Guard in Illinois. But everything else they've won. Justice Sotomayor ruled against them in 24 cases, the 24 times. Justice Kagan, I think, 22 times. So you are seeing a real shift in these cases don't have written opinions, so you don't get what Katie's asking for, which we're pointing you to, which is the ability to read something. You just have immediate one-line reversal, and then laws or government policies get to go in effect. This is really worrisome, obviously. In the tariffs case, I argued the case in the Court of Appeals and won it 7-4. So the tariffs were declared illegal. And I faced enormous pressure from a bazillion people to say, enforce it right away. Stop the tariffs. You've won the case in the Court of Appeals. And I said, no, we're not going to do that. Why? Because then the Trump administration would use an emergency appeal to the Supreme Court and say, restate the tariffs. And they would say it's an emergency and we have all these diplomatic negotiations and this, we need to let the tariffs go into effect. Otherwise, you're going to undermine the president's foreign policy. And I was worried we would lose. So we let the tariffs go into effect despite a decision that we had won. And we extracted from the government a promise that they would pay the tariffs back with interest. And now you're all paying it. You're paying $100 million a month in interest because of what the government had done for those tariffs. But nonetheless, now the money is going back. But that demonstrates, I think, the real worry about the emergency docket, which is the tendency, at least with this court, is to give the administration what they want. And then undermine the decisions of courts of appeals.
Katie, I just wanted to first endorse your homework assignment to our friends. You must, it's not only an opportunity, but a duty to read Supreme Court opinions, the majority and the dissent, and make up your own mind, as Katie says. And the homework for the panel is pick a decision that's being decided recently. It could be the ones on Tuesday or the ones we've discussed, like the tariffs case, and just take the time to read it. You can do it. You don't have to be a lawyer. You can get by all the legal jargon and you'll get the basic idea. But what is the response to the criticism of the shadow docket? And in particular, the New York Times blamed Chief Justice Roberts for starting the whole thing in his memo about an EPA case a while ago.
So I can't talk about that because that was the year that I clerked on the court. So I'm not allowed to talk about that particular year. I do have concerns about the shadow docket just because the amount of work that goes into a Supreme Court brief, the amount of drafts that we go through, the people we talk to. You go and talk to the death penalty scholars. You go and research what happened at the Massachusetts Constitutional Convention in 1829, and we put that in our Supreme Court brief in Moore v. Harper. And you don't have time to do that in an emergency posture. You have 3 days to write that brief that's going to the Supreme Court that's potentially going to decide the law going forward. The other side doesn't have the time. You don't have the time for these amicus groups. So law professors all over the country write these briefs on these really important points. Groups that are impacted, so the criminal defense bar, for instance, writes these really impactful briefs in criminal cases saying, don't do this, court. You will mess up some part of the law. And in the emergency posture, you don't have any of that. So I don't think you have that really deep thinking. The justices don't have a couple months to think about it. The clerks don't have that time. So I think I share that criticism. I think it's hard because the court is dealing with these very big, important issues, and the country does need an answer sometimes on an emergency basis. So it's kind of hard to avoid, but I do think that it shows that we as lawyers actually do contribute to that process and can move the needle, but it works better when you do it on a normal timeline.
All right, we have 3 minutes left. It's time for closing arguments in this marvelous discussion. I know you're both excellent at this. But Neil, this is the 250th anniversary of America. There is no more important cornerstone to the rule of law than judicial independence. Should our friends in the audience and should Americans be optimistic or pessimistic about the nonpartisan independence of the Supreme Court in this crucial time?
I think that it remains to be seen. I can't answer that because I think the next 2 years will really tell us a lot about whether the rule of law survives in the way that we've come to know it. I think there are some hopeful signs, like the tariffs case, a Supreme Court standing up to a president for either its first or second time in American history on something that important. So I think that there are some signs of optimism, but there's also some signs of pessimism, like the Trump immunity decision. And we just don't know. That book has not been written yet. What has been written is, I just want to say, you are getting to hear, I think, in a big public setting from Katie, who is going to be the future of the bar. And so it's been a real privilege, Katie, to watch and work with you.
Well, and Katie, last word, appropriately to you, should Americans be optimistic or pessimistic about judicial independence on our 250th anniversary?
You know, I'm an optimistic person. I think the thing that I struggle with the most is that I put a lot of stake in precedent. And the thing that I like about precedent is it's not just you as a judge thinking. It's like, what did the judge before you think and the judge before that? And so there's this sense of continuity, of history, of tradition. And so what I would like to see the court do is really focus more on upholding precedent, because I think that that's an incredibly rich part of our judicial tradition, and that it makes it less about that individual justice or judge's views. So I think I am optimistic, but I think that that's one thing that I would like to see the Supreme Court focus on going forward.
For giving us some cautious optimism on America's 250th anniversary, please join me in thanking our panelists.